Welcome, everyone. Ron, you want to get started?
New York State Racing Pari-Mutuel Wagering Breeding Law, Section 102 provides that the New York State Gaming Commission shall consist of 7 members appointed by the governor, by and with the advice and consent of the Senate. 4 members confirmed by the New York State Senate are necessary to afford the commission an ability to establish a quorum and undertake action. This present meeting of the commission is now called to order. Ms. Secretary, please call the roll.
John Crotty.
Is it on mute?
Kristen, call the roll.
John Crotty.
She's. You may be muted on your side.
No.
We're not. John Crott. Can you hear us? Can you hear us?
For lack of time, why don't you call the roll, Ron?
Ms. Secretary, John Crotty,
Here.
Peter Machete,
Here.
John Pocalemba,
Here.
Barry Snyder,
Here.
Jerry Skurnick,
Here.
Todd Snyder.
Here.
Ms. Secretary, please have the record reflect the quorum of qualified members is present, thus enabling transaction of business. Chairman Sample.
Would like to go through the minutes of last meeting. Minutes of the commission meeting conducted on May 21st, 2018 have been provided to the members in advance. At this time, I'd like to ask of members if there are any edits, corrections, or amendments. I know they had been revised a few times, and I think we all have a current copy of the most up-to-date. Any changes at all? The secretary should let the record reflect that the minutes have no suggested changes or edits. And could I have a motion, please?
So moved.
Thank you.
Second.
And the motion and the minutes have been accepted. Next on our agenda is the report of the executive director. Ron, please.
This afternoon, I'd like to touch on a few thoroughbred and standardbred items and provide a brief update regarding sports betting. First, Saratoga Racecourse opens for its annual summer meet, bringing the best horses in the world to upstate New York. The 2018 meet will again be the centerpiece of 2 of the greatest days in North American racing. The 2018 summer meet at Saratoga is scheduled to be open from July 20th through September 3rd. After opening weekend, racing will be conducted 6 days a week, Wednesday through Monday. The 40-day meet includes 69 graded stakes races worth $18.8 million of purses, highlighted by the 91st running of the Grade 1 Whitney Stakes and the 149th running of the Grade 1 Travers Stakes. NYRA plans on opening a new amenity called The Stretch. This section is the grandstand near the top of the stretch. Will have multiple types of box seats, a raised circular bar, and touchscreen tablets. The capital project is the first major improvement made to the grandstand since the mid-1960s. On the standardbred side, the 2018 New York Sire Stakes County Fair Series began on July 2nd with racing at Goshen Historic Track. The 2-month series includes 21 race days at fairs across the state, culminating with the $10,000 Hearst County Fair Finals, which is scheduled for September 6th at Monticello Raceway. The County Fair Series consists of 21 non-pari-mutuel harness races open to eligible 2- and 3-year-olds New York standardbred, separated into 8 divisions based on age, gender, and gait. The New York Sire Stakes is designed to promote the breeding, buying, and racing of standardbred horses in New York State and is the nation's oldest harness racing program administered by the Agriculture and New York Horse Breeding Development Fund. As I mentioned at our last meeting, the United States Supreme Court ruled in Murphy versus NCAA regarding sports betting, finding that provisions of the Professional and Amateur Sports Protection Act violated constitutional principles, limiting the federal government from controlling state policy by unconstitutionally forcing states to prohibit sports betting under their own laws. Despite much attention during the recently concluded session, the legislature failed to pass any amendment to the commercial casino gambling law, which might have materially altered the existing New York law, which contains a sports wagering provision that can become effective upon a ruling of a court of competent jurisdiction that such activity is lawful. Commission staff continues to work on regulations that would effectuate sports gambling under existing statutory language. There are, however, a number of thorny policy calls that staff have been considering, including whether the existing law can be read so as to authorize mobile wagering without new statutory enactments, and if so, whether to limit the number of skins available and whether commercial casinos should be required to subscribe or access official league data for resolution of proposition wagers. Staff is likely to engage stakeholders and seek pre-proposed industry comment. We want to make certain that the regulations, when proposed, make sense. Finally, Martin Panzer from NYRA, Senior Vice President of Racing Operation, has requested that the Commission consider Rule 4038.2, minimum price per claim. This rule was adopted following the spat of fatalities at Aqueduct Racetrack at the fall and winter of 2011-12, function prohibiting a horse from running for a purse that exceeds 2 times its claiming price. NYRA contends that while well-intentioned, the circumstances behind the ratio limitation no longer exist, leaving certain NYRA races uncompetitive on a regional basis. NYRA has provided some preliminary material for consideration, along with correspondence from 3 of the 4 members of the New York Task Force on Racehorse Health and Safety, indicating that a modest adjustment in the purse claiming price ratio would likely have an impact on the welfare and safety of, not likely to have an impact on the welfare and safety of horses. As a preliminary point, I have suggested NYRA provide specific information relative to claiming races wherein they are uncompetitive, illustrate how many races of similar level are carded regionally, identify the horses that have approximately started at NYRA properties and then competed at these competing racetracks, and identify how many horses in these higher ratio claiming races have experienced DNF results, traumatic injuries, failed to run back at the expected return, or failed to start again. I will circulate these quantitative materials when they are received. Additionally, if anyone can think of additional materials that would be useful to review when considering NYRA's request, please let me know. Thank you, Mr. Chairman.
Thank you. Any questions or comments on this report? We'll move to rulemaking, please. New York State Parimutuel and Wagering Breeders' Law authorizes the Commission to promulgate rules and regulations that it sees necessary to carry out its responsibilities. In that regard, the Commission will from time to time promulgate rules and rule amendments pursuant to the New York State Administrative Procedure Act. We have 3 items for consideration today. Ron, will you outline the first item?
For Commission consideration is the adoption of proposed rules to prohibit in thoroughbred horse racing the substance that the World Anti-Doping Agency prohibits at all times unless an athlete has an appropriate restricted therapeutic use exemption, to prohibit the experimental use of doping agents with no generally accepted medical use in racehorses, and to require that no drug may be administered to a horse engaged in horse racing activity except as approved by a veterinarian and a valid veterinarian-client relationship. The Association of Racing Commissioners International adopted a national rule that tracks this proposal. The ARCI model rule was drafted with the input and support of the American Association of Equine Veterinarians, the National Horsemen's Benevolent and Protective Association, the Racing Medication Testing Consortium, the Jockey Club, and the Thoroughbred Horsemen's Association. I would also like to note that these proposed rules amendment would implement several proposals recommended by the Commission staff in the staff report in regard to allegations advanced by the People for the Ethical Treatment of Animals in regard to the practice of KDE Equine LLC et al. The proposed rulemaking was published in the May 9, 2018 State Register. The public comment period for the proposal expired July 9. No comments were received. Staff recommends the Commission adopt this proposed rulemaking.
Any questions on the adoption of this rulemaking prohibiting certain practices and doping agents at a veterinary relationship for prescribing drugs in the thoroughbred horse racing? No questions? May I have a motion?
So moved.
Second?
Second.
Discuss the motion? All in favor?
Aye.
Opposed? Motion carries. Thank you.
For
Ron?
Commission consideration is adoption of a proposed amendment to an existing rule that would allow licensed charitable organizations to submit fees through electronic transfer. In general, Commission Rule 4624.9 requires any disbursement from charitable gaming account to be only by check. The purpose of this historical requirement was to increase accountability of charitable expenditures. Receipt of funds by electronic transfer would aid agencies and regulated parties' efficiency substantially by reducing the paperwork involved in submissions, ensuring immediate crediting of organizations' accounts, and automatic the agency depositing function, all without sacrificing safety, security, or accountability. The proposed rulemaking was published in the May 16, 2018 State Register, meaning that public comment period expires today. To date, no comments have been received. In the event additional comments are received before the close of visit, staff will promptly inform each commissioner. Staff recommends the Commission adopt this proposed rulemaking.
Any questions regarding this rulemaking regarding special bell jar accounts? May I have a motion?
So moved.
Second?
Second.
Discussion of the motion?
Mr. Chairman?
Yes.
If I may just make one point too, the public comment period is due to expire today, and we should make sure that a motion to adopt would be contingent on no material comments being made before the end of business.
Yeah,
Okay.
I can modify my motion to
Thank
adopt
you.
that.
Do I have a second on the modified motion?
Second.
All in favor?
Aye.
Any opposed? Motion carries. Ron?
For commission consideration is the addition of a blackjack table side wager called Blazing Sevens Progressive at the request of a casino licensee pursuant to Commission Rule 5323.19. Temporary rules for this side wager to the game of blackjack were approved for play through October 26, 2018. The Commission's Division of Gaming has evaluated the experience with this game and is satisfied that this wager would be appropriate to add to the table game rules as a permanent rule. Staff recommends the Commission authorize the proposed rulemaking.
May I have a motion to this proposed rule?
So moved.
Second?
Second.
Any discussion? All in favor?
Aye.
Opposed? Motion carries. We have, I think, about a half dozen adjudications for today. And Ron, could you?
In the matter of
Start, please.
Gonzalez Grocery Store, on January 24, 2018, the Bureau of Licensing issued a notice of license suspension and ordered the immediate temporary suspension of the lottery sales agent license of a Gonzalez Grocery Store, which is located at 2665 Valentine Avenue in the Bronx. The notice informed Gonzalez Grocery Store that the suspension was for fraud, deceit, misrepresentation, or conduct prejudicial to public confidence in the state lottery. Specifically, the notice stated that the store personnel had sold instant game lottery tickets from the ticket books that had not been activated. The notice also stated that the suspension could become a revocation unless Gonzalez Grocery Store requested a hearing. After a request by Gonzalez Grocery Store, a hearing was conducted on May 23, 2018. The owner of the retailer submitted a letter for consideration but did not attend the hearing. The hearing officer submitted a report to the Commission Secretary dated June 8, 2018, recommending that the license be revoked and that the period from the date of suspension to the Commission's decision serve as suspension of license. The Commission considered this matter at a meeting conducted pursuant to the judiciary quasi-judicial proceedings exemption of the New York Public Officers Law, Section 108.1.
The Commission considered this matter and determined upon a 6-0 vote to sustain the hearing officer's report and recommendations. Next item, Ron.
In the matter of Jenny Food Corporation, on November 7, 2017, the Bureau of Licensing issued a notice of license suspension and ordered the immediate temporary suspension of the lottery sales agent license of Jenny Food Corporation, which is located at 2026 7th Avenue in Manhattan. The notice informed Jenny Food that the suspension was for fraud, deceit, misrepresentation, or conduct prejudicial to public confidence in the state lottery. Specifically, the notice stated that the store personnel had discounted prize-winning lottery tickets. The notice stated that the suspension would become a revocation unless Jenny Food requested a hearing. On November 10, 2017, the Bureau of Licensing issued an amended notice of license suspension notifying Jenny Food that in addition to the aforementioned, an additional ground for suspension was failure to timely remit funds due to the division of the lottery. After request by Jenny Food, a hearing was conducted on May 8, 2018. The hearing officer submitted a report to the Commission Secretary dated June 8, 2018, recommending that the license be revoked and that the period from the date of suspension to the Commission's decision serve as suspension of license. The Commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The Commission considered this matter and determined upon a 6-0 vote to sustain the hearing officer's report and recommendations. Next item.
In the matter of Dennis Martin, on February 13, 2018, the Bureau of Licensing denied the application of Dennis Martin for a non-gaming employee registration as a cook at Resorts World Catskills, citing Racing Parimutuel Wagering Breeding Law, Section 1318. Staff indicated that the applicant had misrepresented certain information and provided false information on his registration application. Among the Section 1318 disqualifying criteria are A, failure of the applicant to prove by clear and convincing evidence that the applicant is qualified in accordance with the provisions of this article. B, failure of the applicant to provide information, documentation, and assurances required by this article or requested by the commission, or failure of the applicant to reveal any fact material to qualification, or the supplying of information which is untrue or misleading as to a material fact pertaining to the qualification criteria. C, the conviction of the applicant or of any offense in any jurisdiction which is or would be a felony or other crime involving public integrity, embezzlement, theft, fraud, or perjury. Mr. Martin requested a hearing which was conducted on May 11, 2018. The hearing officer submitted a report dated June 20, 2018, recommending that the registration denial be upheld. The Commission considered this matter at a meeting conducted pursuant to the Judicial Quasi-Judicial Proceedings exemption of New York Public Officers Law 108.1.
The Commission considered this matter and determined upon the 6-0 vote to sustain the hearing officer's report and recommendations.
In the matter of Ebony Walker, on January 29, 2018, the Bureau of Licensing denied the application of Ebony Walker for a non-gaming employer registration as a kitchen steward at Resorts World Catskill, citing racing, parimutuel wagering, breeding law, section 1318. Staff indicated the applicant had open or pending criminal charges disclosed on her registration application. Among the section 1318.1 disqualifying criteria are: A, failure of the applicant to prove by clear and convincing evidence that the applicant is qualified in accordance with the provisions of this article. B, failure of the applicant to provide information, documentation, and assurances required by this article or requested by the Commission, or failure of the applicant to reveal any fact material to the qualification, or the supplying of information which is untrue or misleading as to a material fact pertaining to the qualification criteria. C, the conviction of the applicant of any offense in any jurisdiction which is or would be a felony or other crime involving public integrity, embezzlement, theft, fraud, or perjury. G, current prosecution or pending charges in any jurisdiction of the applicant or of any person who is required to be qualified under this article as a condition of a license for any of the offenses enumerated in paragraph C of subdivision 1 of this section, provided, however, that at the request of the applicant or the person charged, the Commission may defer the decision upon applicant during the pendency of such charge. Walker requested a hearing which was conducted on May 11, 2018. The hearing officer submitted a report dated June 15, 2018, recommending that the registration denial be upheld. The Commission considered this matter at a meeting conducted pursuant to the Judicial or Quasi-Judicial Proceedings exemption of New York Public Officers Law 108.1.
The Commission considered this matter and determined upon the 6-0 vote to sustain the hearing officer's report and recommendations.
In the matter of Reginald Gibson, in February 2018, the Bureau of Licensing denied the application of Reginald Gibson for a non-gaming employee registration as a kitchen steward or cook at Resorts World Catskill, citing racing, parimutuel wagering, breeding law, section 1318. Staff indicated that the applicant failed to provide information and documentation requested and provided misleading information on his registration application. Among this section's 1318.1 disqualifying criteria are: A, failure of the applicant to prove by clear and convincing evidence that the applicant is qualified in accordance with the provisions of this article. B, failure of the applicant to provide information, documentation, assurances required by this article or requested by the Commission, or failure of the applicant to reveal any fact material to qualification, or the supplying of information which is untrue or misleading as to material fact pertaining to the qualification criteria. C, the conviction of the applicant of any offense in any jurisdiction which is or would be a felony or other crime involving public integrity, embezzlement, theft, fraud, or perjury. Gibson requested a hearing which was held on May 24, 2018. The hearing officer submitted a report dated July 2, 2018, recommending that the registration denial be upheld. The Commission considered this matter at a meeting conducted pursuant to the Judicial or Quasi-Judicial Proceedings exemption of New York Public Officers Law 108.1.
The Commission considered this matter and determined upon a 6-0 vote to sustain the hearings officer's report and recommendations. That's it for the adjudications, correct?
Yes, sir.
Okay. Is there any old business that members want to raise? Any new business? We have no items scheduled as new business. And does anyone have any new business to consider? Well, with the permission of everyone here, I would like to bring forward an application to reopen the adjudicatory matter, specifically in the matter of Richard E. Dutrow Jr. As you all know, thoroughbred trainer Rick Dutrow, by his attorneys, previously filed an application to reopen an adjudicatory proceeding for consideration of a modified penalty pursuant to Commission Rule 4550.10B and C. The Racing and Wagering Board, a predecessor agency to this commission, determined that Mr. Dutrow was ineligible to reapply for any license issued by the commission for 10 years from the revocation of his license on January 17, 2013, and fined him $50,000. The matter was discussed at our pre-adjudication meeting, and the members have decided in a vote of 4-2 to not reopen the case at this time. Next item is the scheduling of our next meeting. If we went by our normal schedule, the scheduling of the next meeting would be August 27th. And that was, we're planning on doing it in Saratoga. Kristen will work with all of us to try to sort out an appropriate date if that does not work for everyone, but we should try to do a meeting in Saratoga before the season, before that session ends. That concludes our published agenda for today. The commissioners have any items they'd like to present for consideration at all? Okay. Hearing none, no other items for consideration, this meeting is adjourned. Thank you.
Thank you, Mr. Chairman.